Hi everyone, my name is Maria. I'm a criminal justice major in my junior year here at Houston Christian University. Please allow me to provide you all with a trigger warning before I begin my speech today. My topic may be sensitive, especially for those of you who have experienced sexual assault yourselves or know someone who has. Please prioritize your well-being by any means necessary if you find this topic triggering. My presentation will cover the evolution and history of sexual assault and its laws based on compelling statistics from the National Sexual Violence Resource Center, historical context from the sources such as U.S. Department of Justice and Columbia University, and others, as well as historical and personal case examples. The purpose of this informative speech is to connect the history and evolution of sexual assault and its laws to the practical implications for future criminal justice professionals, and to emphasize how an in-depth understanding of these laws would better equip us with the knowledge to navigate and contribute effectively to the legal system. According to the National Sexual Violence Resource Center, 1 in 5 women has experienced completed or attempted rape, and nearly a quarter of men in the United States has experienced some form of sexual assault during their lifetime. It's disheartening to have to acknowledge that 1 in 3 female and 1 in 4 male victims of completed or attempted rape experienced it for the first time between the ages of 11 and 17. These figures emphasize the urgent need for awareness and action to address these heinous crimes. Someone you know could be one of the 630,000 people who were sexually assaulted in the U.S. in 2018. But did you know that only 25%, that's 183,657 of these sexual assaults were reported to police that year? I'm sure right now you may be asking yourselves, how many of those reports are false, right? Well, according to statistics, the prevalence of false reporting sexual assault crime is low, falling between 2 and 10%. So far, I've discussed statistics regarding reported sexual assaults. Now let's examine the other 75% of sexual assaults that were not reported to the police. The first question that comes to mind for many is why? Why didn't they say anything? Why didn't they report it to the police? Why did they not fight back, or run, or scream? I would have to say the answer to that is history. Before I take you on a journey to the past to see the evolution of sexual assault and its laws, allow me to define sexual assault or rape according to its history. According to an article from Columbia University titled "A Reflection on the History of Sexual Assault Laws in the United States," in ancient times, rape was defined as the defilement of a man's property. It wasn't until the early 11th and 12th centuries that rape began to be considered a violent crime against the victim. Early American colonies defined rape as carnal knowledge of a woman 10 years or older, forcibly and against her will. Yes, 10 was the age of consent until the late 1800s. An article in the National Institute of Justice written in October of 2010 states rape is defined in most states as non-consensual oral, anal, or vaginal penetration of the victim by body parts or objects using force, threats of bodily harm, or by taking advantage of a victim who is incapacitated or otherwise incapable of giving consent. Now that we see how the definition of sexual assault or rape has evolved, let's review the evolution of its laws. Another Columbia University article titled "History of Sexual Abuse and Harassment" reveals that in 1750 BCE, Hammurabi's law code considered the rape of a woman a property crime against the victim's husband or her father. Today, that would be equivalent to someone stealing your shoes or your dog. Hebrew punished rape by stoning. If a virgin was raped inside the city limits, where she could have cried out for help, she was stoned to death along with her rapist. But if it was outside of the city limits, where she could not have been heard, she had to marry her assailant. Ancient Greeks considered rape of males as well as females, and punished the crimes in a more humane manner, mostly with fines. By the end of the 13th century, the crime of rape applied to all women, including prostitutes, and a suit could be filed by the state, if not by the victim's family. However, victims were still mistrusted and went through strenuous examinations of their reputations, having to prove that they were sexually assaulted. In the 1500s, marital rape was not a crime in Massachusetts, so there was no longer a need for anyone to corroborate the victim's testimony. Currently, 12 states in the U.S. follow this law. In the 17th century, according to an article titled "Timeline of History of Sexual Violence in the U.S., Black women were victimized by a 1662 law stating that any children resulting from rape against a slave would legally become the property of the slave owner, thus creating an economic incentive for white slave owners to rape Black women because legally it was not necessary for them to give consent in a sexual encounter. Historically speaking, victims of sexual assault were often blamed or chastised due to societal norms, mistrust, and a lack of understanding about consent, therefore discouraging victims to come forward. Now, let's discuss the results of this discouraging behavior on behalf of law enforcement and society and its effect on contemporary times. Historically, sexual assault has not been regarded as a violent or even serious crime. The victims have been chastised and have received less dignity and respect than the perpetrators, particularly for women. Proving without a doubt that they did not consent to sexual encounters has proved challenging, perhaps impossible, thus answering in part the question of why. Considering all the information I've presented thus far, how has our understanding of sexual assault, its laws, and the status of victims evolved in today's context? As a hub for advocates, researchers, and educators who are passionate about supporting survivors and building communities free of sexual assault, harassment, and abuse, the National Sexual Violence Resource Center has been dedicated to offering resources on preventing sexual violence for over 20 years. According to their article, 20 Events That Shaped Sexual Violence Prevention in the Last 20 Years, the center offers various resources on preventing sexual violence. Public exposure to sexual assault issues through local awareness events and national media coverage has been on the rise since the year 2000, enabling victims of sexual assault to use their voices through acts passed by legislation, campaigns, programs, and social movements against sexual violence, such as the Violence Against Women Act, reauthorized in 2005, 2013, and again in 2015, the Me Too movement, founded in 2006 and going viral in 2017, the Hate Crimes Prevention Act, signed into law in 2009, and so many more. Research shows the evolution of not only society's and law enforcement's view on sexual assault, but also the evolution of its victims' endurance. Due to my personal experience as a survivor of sexual assault, the 1991 U.S. Supreme Court decision on sexual assault was one of the most significant changes. According to the U.S. Department of Justice article, Victims as Storytellers, the Impact of Victim Impact Testimony in Criminal Justice Proceedings, Part 1, published in 2002, the U.S. Supreme Court recognized that victim impact testimony played a pivotal role in the 1991 Payne v. Tennessee case, which led the state legislature to allow victim impact statements in case proceedings, thus expanding victim roles in the courtroom. As you can see, the most significant contributions to understanding the history and evolution of sexual assault, its laws, and the impact it has on the victims are paying close attention to sexual abuse violence data and statistics, recognizing the systemic barriers, fears, shame, and societal pressures that often prevent victims from coming forward by navigating through historical context, helping create a supportive environment where rather than facing blame or judgment, victims can feel safe and empowered to use their voices and speak up, and comprehending the depth of pain, fear, and devastation caused by sexual assault, with the inclusion of first-hand narrative victim impact statements in court proceedings. I will leave you with this. Allowing victim impact statements in court proceedings was instrumental to my journey as a survivor. These statements give a voice to the voiceless, advocate for change in the justice system, and allow victims to transform into survivors. Personally, I was finally able to express the emotional, psychological, and personal impact sexual violence had in my life. This allowed my voice to contribute to the legal process while enabling personal healing and closure.